This is People of the State of Michigan versus Isaiah Dumont, docket number 20-910FC. And I'm told this is the time set for a guilty plea. Is that correct, Mr. Silverthorne?
Yes, Your Honor.
Okay, Mr. Dumont, would you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You can put your hand down. And Mr. Dumont, you have the right to be represented by an attorney. You are represented by Mr. Silverthorne. And Mr. Martin is here for the people. And I know we talked about this in advance, but remind me which count it's a plea to.
Yes, he'll be pleading to count 3 on the original information.
Yeah, okay. And then Mr. Silverthorne, you'll waive reading of the other counts?
Yes, Your Honor.
Okay, Mr. Martin, would you read count 3, please?
Yes, Your Honor. The State of Michigan, County of Ingham, in the name of the people of the State of Michigan, the prosecuting attorney for this county appears before the court and informs the court that on or about June 27, 2020, at 244 Mosley Avenue, City of Lansing, Ingham County, Michigan, the defendant did, in count 3, controlled substance, delivery, manufacture, cocaine, heroin, or other narcotic less than 50 grams, did deliver less than 50 grams of a mixture containing the controlled substance fentanyl, contrary to Michigan law. This is a felony punishable by 20 years and or a fine of $25,000. This act was done against the peace and dignity of the people of the State of Michigan.
Mr. Dumont, you're being charged here with what's known as delivery of less than 50 grams of fentanyl. That is a felony punishable by up to 20 years in prison. And if you were on parole at the time you committed the offense, it would be a mandatory consecutive sentence. Have you had enough time to talk about this charge with your attorney?
Yes, I have.
And do you understand the charge against you?
Yes.
Do you have any questions about what we're doing?
No.
Okay, how do you want to plead?
I plead guilty.
If your plea of guilty is accepted by this court, it means you won't have a trial of any kind, and you'll be giving up the rights that go along with the trial. I'm going to go through those with you. You'll be giving up the right to a trial by jury, or if you didn't want trial by jury, trial by judge. You'll give up the right to be presumed innocent until proven guilty, and to require the prosecutor to prove your guilt beyond a reasonable doubt. You'll give up your right to have the witnesses against you appear at the trial and to be able to cross-examine them. Also, your right to have this court order any witnesses that you might have to appear at the trial. You'll give up your right to remain silent at the trial and not to have that silence used against you, or if you wanted to testify at the trial. Also, there's some things that are different when you plead guilty regarding appeals. One is that you can appeal to the higher court only by asking their permission to hear the case and by them granting it. So in other words, you don't get an automatic right to appeal. And then the other one is that there are issues you cannot appeal to the higher court when you plead guilty, unlike if you go to trial and get convicted. Do you understand those rights, Mr. Dumont?
Yes, I do.
And also, if I accept your plea, it means you cannot come back later on and try to say that the plea was the result of some promise or threat that no one told me about today. Do you understand that?
Yes.
It also means you can't come back later on and try to say that it really wasn't your own choice to plead guilty today. Do you understand that?
Yes.
Is there a plea agreement, Mr. Martin?
There is, Your Honor. In exchange for the defendant's guilty plea in count 3, the people agreed to dismiss counts 1 and 2 on the original information. There is an agreement in this matter pursuant to People versus Killebrew that the minimum prison sentence on this case will be 34 months in the Department of Corrections, making the sentence 34 to 240 months in the Department of Corrections.
So your agreement is for a fixed minimum of 34 months?
That is our agreement.
Okay, all right, go on. I'm sorry to interrupt you. I wanted to make sure.
Absolutely. Further, to the extent that that boot camp is an option for this defendant, as we've discussed previously, the people would oppose boot camp in this case.
All right, and Mr. Silverthorne, is that a full and complete statement?
We all had also agreed that he would get concurrent time in the file that was before your honor about a month or so ago in 20-713 FH. That would be a case that actually was handled more quickly than this case, but it was a case that whose date of event occurred after the event in this case.
I think we discussed that. You agree with that, Mr. Martin?
That is correct. I'm sorry I left that detail out.
Okay, yeah, and I've already indicated that I would discharge him from probation on that previous case, and I've already communicated that to the probation agent as well. So is that now a full and complete statement, Mr. Silverthorne, with your addition there?
Yes, Your Honor.
And Mr. Dumont, is that all your understanding of the agreement as well?
Yes, I thought it would be no more than 34 months would be my, the max that I could get.
Well, what they're telling me is that it's a fixed 34 months on the low end. It's not a no more than 34 months. Is that your understanding or not?
My understanding was it would be no more than 34 months.
Okay, I'm looking to Mr. Martin or Mr. Silverthorne to either.
Well,
I guess I'd have to refer to an email real quickly to see what it was. If I can minimize the screen for a moment.
Sure.
My computer is a little slow for some reason today.
So I would say it's 21 then. None of those in there are straight. And that has community restrooms. Oh, really? Yeah.
I'm reading from an email of December 3rd, Mr. Martin. At this point, I can offer for him to plead to delivery on the D grid with an agreement that his minimum sentence not exceed 34 months. That seems the cleanest way to do it. No objection.
All right, that's not a fixed.
okay, so if we could amend the agreement to be that his minimum will not exceed 34 months, which is the low end of the guidelines on the D grid based on the OVs in this case.
Okay, so the agreement is that his minimum sentence would not exceed 34 months.
Correct.
Now, it seems like Mr. Dumont, you understood that ahead of everybody else. So is that now your complete understanding of the agreement?
Yes,
And you agree with it?
yes,
Okay, so the agreement on your sentence is that the low end of your sentence would be no more than 34 months. If for some reason I said I'm not going along with that, in other words, if I said I wanted to give you more than that, I would tell you before I sentenced you, and I'd give you a chance to take back this plea and start all over. You got all that?
yes.
Has anyone promised you anything else that has not been said here right now in order to get you to plead guilty?
No,
Has anyone used any threats to get you to plead guilty?
no, Your Honor.
Is this your own choice?
Yes,
And are you pleading guilty because you believe you are in fact guilty of this offense?
yes,
Okay, we're talking then about count 3, the delivery of fentanyl. Tell me what you did on or about June 27th of 2020.
I sold 2 pills in exchange for money.
Okay, and what were those pills?
They were Roxy Cotton.
Okay, you believed it to be Oxycontin?
Yes,
Have you seen, in the process of working on this case with your lawyer, have you seen a laboratory analysis of the substance?
yeah, it said it was contained fentanyl.
Fentanyl, okay, you don't dispute that?
No,
Was it less than 50 grams?
yes,
And when you say you sold it, did you hand it over to someone else?
yes,
And did that happen in the area of 244 Mosley Avenue in Lansing, Ingham County?
yes, Your Honor.
Did I ask, is it less than 50 grams? I can't remember now.
Yes, you did.
You
Your
did,
Honor.
Your Honor.
Yeah, okay. Has the court complied with MCR 6.302, Mr. Martin?
You have, Your Honor.
Mr. Silverthorne?
Yes, Your Honor, you have.
Are you aware of any promises, threats, or inducements other than those already placed on the record, Mr. Martin?
No, Your Honor.
Mr. Silverthorne?
No, Your Honor.
The court finds the plea is understandingly and voluntarily made without undue influence, threats, or promises of leniency. It is an accurate plea. It's supported by the testimony. The plea is accepted. And I've got to get a sentencing date. If you can hold on 1 minute. In custody is supposed to be 5, I think. Okay, thank you. Monday, March 1st at 2 o'clock. Is that okay for you, Mr. Silverthorne?
That'll be fine, Your Honor.
Okay, looks like Mr. Martin's good with it. So, Mr. Dumont, maybe you need to talk to your lawyer about this, but at least right now off the top of your head, do you think it's okay with you if I do the sentencing remotely the same way I took this plea?
Yes,
Okay, thank you. Then we will plan, unless it's otherwise changed, to do this remotely from the jail on March 1st at 2 o'clock. And Mr. Dumont, you will have another interview because it's a different offense. So you'll have another interview with the probation department because they have to prepare a whole new report for me to use for sentencing. So you should just be aware that they'll be contacting you for that. Okay, do you have any questions?
no, I don't.
Okay, then that'll conclude our hearing. You can tell them they're at the jail that you're all set.
All right, thank you.